Justice Millette, what's your view on this?
I agree completely with Chief Justice Kinzer. I would just add a couple of things. I think that it's a very important, and I don't think it's that hard to do, to set aside your political leanings. As the Chief Justice mentioned, your biases and prejudice that may be based upon political philosophy. Don't have much difficulty in setting those aside. What life experiences I have as far as being a lawyer and a trial judge, I think basically have helped shape me, and I think I have to use those. I was a trial lawyer for 16 years and a trial judge for almost 18 years, and I tried a lot of the kinds of cases and was involved in the kind of cases that are now heard by this court. So I think that those experiences certainly have shaped the way that I approach my job at this point in time. And I think that's important for members of a court to do that.
So, Justice Millette, back to you. We're talking now a little bit about the line between interpreting and legislating, as some commentators use the term. How do you find that line? Is there an easy way to determine where the line is between the two?
I don't think so at all. I think you usually have to use everything you've ever been able to understand as either a lawyer or a judge to try to figure out where that line would be. I would think that what you try to do is keep in mind, again, what our role is. Our role is to resolve disputes, to resolve the matters that come before us, and as an appellate court, to give guidance to the lower courts and to give guidance to the litigants as to how we came to that decision. And I don't think that that's a legislating. I think it's a deciding the case.
Yeah, Justice Millette.
I had a thought about that. When I was a trial judge, I used to always talk to the jurors at the end of their term, and I was always impressed by how much they enjoyed and appreciated the experience. And I think they got a lot out of it and a lot of understanding of how the judicial system works. Now, of course, we're faced with declining jury trials in our court system. And there is always a limited number of people that can be involved as jurors, but that certainly seems to be a way for people to become participants and to understand the system. So that's one thought.
So let's talk about then the process of judging. Let's move into the nuts and bolts since Justice Mims started on that. And Justice Millette, I was wondering if I could start with you. So the clerk's office dumps on your desk a whole stack of documents for a case. Talk to us about how you approach the case. How do you get your arms around it? Do you always start by reading the record first? Do you have a different approach for different kinds of cases? How do you start to get engaged with a case?
I'll be happy to answer that question, but maybe we should go back, because I disagree with his answer on the first question.
I would love to.
I thought you might want to hear a disagreement.
Please do.
Okay. Maybe this is the first time we've had a disagreement in the panel so far, but I disagree with Justice Mims. I think there are areas of the law that have been underdeveloped. And primarily it's an area of the law where there is some change. Let me give you two examples. One example is, I believe there's recently been an increase of the number of claims for defamation involved with employment cases. It's a way of looking at some old law. We've had defamation law for a long period of time, but now we're trying to apply it into a new area, in the area of employment. And I think employment lawyers are seeing that as a possible fruitful way to recover damages against employers. And so I believe we have not developed that enough. Now, I agree with Justice Mims, we will develop it as the cases come to us, but that's one of the areas where I think we have not been able to develop the law fully enough. Another example I'll give you is a case that we had a year or two ago. It happened to be an asbestos case, and it happened to involve multiple sources of causation. And we came up with, actually I wrote the opinion, and we came up with an analysis that was slightly different than what had been used before, and that's another area of the law that needs to be developed. So there are areas, I think, that are underdeveloped in our case law.
And so when you say that those particular cases or areas are underdeveloped, do you mean that the opportunity didn't present itself in the cases that you've heard to develop the law, that the court wasn't ready at that point to take that extra step? What do you mean when you say underdeveloped?
I don't agree with your comment about the court being ready to take an extra step. We address the issues that are before us, and I think all of us have been frustrated by having a case in front of us that perhaps the assignment of error does not direct us to the area that we'd like to discuss, and therefore we feel constrained because we are limited by what the assignments of error are that the parties bring to us. So that's an example of an area where we're ready to talk about it, but the case is not in the right posture for us to do it, so we've got to wait for the next case. And in the example I gave you about the multiple causation, we talked about the particular case as much as we could, but there are certainly going to be other cases that are going to develop nuances or other ways of developing that law, and that's just going to have to come as the case law comes to us.
So as a strategic matter then, does it behoove counsel to raise as many issues in the brief as they think there are possible assignments of error to give the court perhaps an opportunity? Or does the court actually respond negatively to having a brief that has too many issues in it? Justice Millette? What?
Personally, I think I respond negatively to it. I think if you've got some really good points, you should focus on the really good points rather than just sort of the shotgun approach and saying, I hope something sticks against the wall. Having said that, it is almost asking us to read our minds to say, well, how do I know what's going to be really important? I think if you really understand the law, if you've studied the law of your particular case and you know the facts of your case real well, you'll be able to divine, actually that's a poor choice of words, you'll be able to understand what are the real issues that need to be addressed.
Well, let's now turn to the issue of how you start engaging with a case. So let me return to the question that I posed
I avoided
earlier.
last time? Okay.
And then Chief Justice Ginsburg, maybe I'll ask you to comment as well. So you get the stack of papers, the briefs and the record on your desk. How do you first dig in?
Interestingly, we have most of the cases that we deal with have already had a writ memo prepared by one of our chief staff attorneys or our own law clerks. And that writ memo has gone to the writ panel, the three-justice panel, and the panel has decided that they're going to grant the writ on that. So I usually start there because it's sort of an overview of the case, and it's usually about 10, 12 pages, so it gets you a good overview of the case fairly quickly. I then look at the appellant's brief, and as I'm reading the appellant's brief, I will go through the record. Now, almost always I'll read the complaint, one of the first things I do, because almost always in every case, it's a civil case, the complaint is going to have some impact on the outcome of the case. But I do want to understand what the facts of the case are and the way the case is set up. And after I've read the appellant's brief and perused the record, then I'll read the appellee's brief and look at the record as part of that.
Justice Millette, do you talk to me about your process again in going through the case? You talked a little bit about how you approach the case. At what point are you persuaded, or do you start to form your view? Do you form it as you're reading the briefs? Do you wait for oral argument?
I think I form it as I'm reading the briefs. Certainly, as I understand the case more and more, and I understand the parties' positions more and more, I start to feel more comfortable that I agree or disagree with whatever the appellant is arguing or whatever the appellee is arguing. But I don't make a final decision. I'm convinced until I've heard everything. Certainly, even the oral argument. I've changed my mind a number of times after hearing the oral argument, and I think it's just the nature of the decision-making process. I try to be as clear as I can, and I think the primary audience that I'm writing for are the trial judges and the trial lawyers. And I remember from my time in both of those roles that you really don't have the time to look for nuances in a particular opinion. You really want to know what you're supposed to do when you have this kind of issue come before you. And I think that a style that makes it as clear as possible for the trial judges and trial lawyers is the best style to use, and that's what I try to do. And I think by doing that, hopefully the litigants in a particular case also understand where I'm coming from.
So would you say that's the hallmark of your style? So what is it about your style that you said you think somebody could recognize an opinion as yours?
If it's simple enough to understand, for me to understand, then it's probably a good opinion.
Okay.
You know, I think it's sort of the law of unintended consequences. Sometimes your opinion will come out and people will interpret it differently than you thought. And to me, one of the best ways of avoiding that is the wisdom and experience of my colleagues, to be quite frank with you. A lot of judging has to do with experience. And so when we have people that have had more experience on the bench and they say, well, you know, we had this come up 7 or 8 years ago, and in that case we said this, and you're saying this in this particular case, might cause a concern. And it really helps a lot, and it makes you feel a lot more confident about your opinion when you've had that feedback from your colleagues that you really might want to tweak that and make that a little more clear.
I suppose it also requires a certain level of humility not to be too wedded to your own first draft, I guess.
Yes, I think that's probably true, and I think all of us are pretty much like that. At least I hope we are, because it's not the writing that's so hard; it's the rewriting, right?
Exactly right. Exactly right.
There's a question.
I know that there are times when I may think that I've got a couple of votes from the way the questions are being asked, and I want to try to nail down my fourth vote, so I've got a majority, and I want to make sure that the person who's arguing has a chance to really explain what I think they may have said in the brief, and they may have not brought it out as clearly as I'd like them to have brought it out to the rest of the court. So it's actually almost a preview of the argument we're going to make later on at the opinion conference to get that kind of question out there.
Do you think counsel recognize that's what you're doing?
I hope so, and I can tell you sometimes they don't, because sometimes the rest of us will sit there and say, "Counselor, that was a softball question." It really was not a hardball question, and so sometimes they don't understand it, but I think a lot of times they do.
So what sort of advice then would you give to attorneys at argument along those lines?
Listen, listen, listen. I think too often attorneys come into oral argument with a preconceived notion of what they want to tell us, and unfortunately sometimes it's just a restatement of what they've already put in their written briefs. That's not what we're looking for. I think the most important asset that a litigant can have, an oral argument before us, is to listen closely to what the questions are and to see where we're trying to go and answer the question, and then of course get back to your own argument if you fully answer our questions. But I don't think you can listen too closely. I was with a small firm for 6 years, then I was a sole practitioner actually for 6 years, and then a prosecutor for 4 years. So I basically was in court every day, and in all the courts. I was in district court, I was in circuit court, I was in juvenile courts. So I had a pretty broad understanding of the kind of issues that eventually work their way to circuit court and then eventually work their way to the appellate court.
Has that affected not only how you perform your role now, but your view of the judiciary or what courts should do?
Certainly. I remember specifically some judges that I was just incredibly impressed with and thought those were the kinds of people that I would like to emulate if I ever could be a judge myself. Now I got to say I never thought I was going to be a judge, first of all, and certainly not on the Supreme Court when I first started practicing. It was not in my contemplation. It's just something that developed as my law practice and my career went on.
Was that a difficult decision for you to accept the nomination?
Actually, I became a substitute judge pretty early on. I was 30 years old, and when I first started, I said, well, I think I really like this position. I think I can do this fairly well, and I think that it's something I'd like to pursue. I think how relentless the pressure of the job is, to be honest with you. I was a circuit court judge for a long time, and I thought I worked very hard. But one of the things about being a circuit court judge is when you complete a week trial or 2-week trial, you have to forget about it when you go home that night, because the next day you may have a domestic relations case. Here, you work on these cases, and then you think about them at night, and you think about them all weekend, and you think about them the next day, and you write your opinion, and you still keep thinking about it. And there really doesn't seem to be a time when you don't feel the pressure of getting the case right. I thought when I took the job, I thought, well, I'm going to have a job where I have a little more control of my time, a little more time management, because heck, they only go to court once every 7 weeks. You know, that's a lot of free time in there, and it has not worked out that way.
And there's not as many people you get to talk about it with either.
Now,
right?
the positive side of all that is, it is absolutely the most amazing experience you can have to put together everything you ever learned as a law student, as a trial lawyer, as a trial judge, as an appellate judge, to put it all together and to try to get the very best product you can get. And it is a real feeling of satisfaction, but it's not without the cost of feeling some pressure on you.